الله والله يا الله والله حق الله يا الله حق الله والله يا الله والله.
Assalamu alaikum wa rahmatullahi wa barakatuh. My name is Shahzad Siddiqui. I'm a lawyer here in Toronto, Ontario, Canada, and I practice Islamic finance. I do corporate and commercial litigation, and I have a special interest in wills and estates, including Sharia-compliant wills, estates, and trust planning, and waqf, known as awqaf, plural, within the Islamic tradition. So I'm happy to speak to you today as we draw close to the end of Ramadan, and I'd like to speak in detail about these three topics with respect to the will and testament, the waqf, and other components that arise out of that, such as a family trust that people can use to their benefit in Ontario, both for religious purposes and for secular ones. So I'd like to begin with two hadith that pertain to the will. As many in our community know, it's incumbent upon us to write our will, especially in light of the first hadith, which is that no Muslim with assets to bequeath should spend more than 2 nights without having their will written and ready with them. And then more generally, the Prophet, peace be upon him, said, learn estate division, because I am someone who will be taken from you, and this knowledge will be taken from you until there comes a day where 2 men shall dispute about the obligatory share, and there shall be no one to judge between them. So with those two hadith in mind, we have to ask the central question of what is a will, and what does it do for somebody. And then we'll follow up with why it's important within the Islamic tradition to do one, why there are these two specific hadith about it. So a will can be an oral testification under Islamic law, but in Ontario, it has to be a written document. And in Ontario, it has to be with certain requirements that I will spell out, but it has to be in written form, because of the disputes that can arise if it is orally given. And so we begin with some of the requirements of what would be in a will in Ontario, and that would obviously be somebody's name, who they appoint as an executor, otherwise known as an estate trustee, otherwise known as a trustee. That is the person responsible for gathering the financial assets of the estate and distributing them to the beneficiaries. So that is a very important function of a will. Without an executor named in the will is invalid. So obviously that has to be a trusted family member or a friend. Generally speaking, it's a spouse, and it can also be a child that's over the age of 18. It can also be a close family friend, as I mentioned, somebody who's probably adept at financial planning. Generally speaking, we don't recommend in Ontario that somebody be a foreigner, or even if they're a Canadian citizen, that they reside outside of Canada for more than 183 days. And the reason that is because you then have to put in what they call a foreign executor's bond into court, to essentially provide security for assets that are flowing outside of Canada to an executor abroad. So we recommend it be somebody here. That is different from the guardian of the children. So the guardian of the children would obviously be for people who are under the age of 18 who require such a person. And once again, it would automatically be the spouse, even if there's been a divorce or separation between the spouses. So the first person in line would be the spouse or an ex-spouse. And then after that, it would be somebody that you appoint, which could be another child who's over the age of 18. So once you have the executor and the trustee who've been listed in the will, you get into issues like gifts and bequests that one makes through the will. And so that could be a special automobile that you want to give to somebody specific. It could be a stamp collection. Very often with women, they make provision within their lifetime to give jewelry to certain members of their family, which tends to be the daughters and tends to be for their marriage. And so that can be specified in the will. So other than those very tangible assets, like a stamp collection or a special car or jewelry, you can then get into the most important part of the will, which tends to be the residue of the estate. And that is after payment of debts, expenses, and taxes. So the residue, the estate, is everything essentially left over after somebody's liabilities have been paid out. Now, the will can also have Islamic components in it, the most important of which are likely four. One, you could have a religious preamble in the will that sets out some instructions, words to the living. My father-in-law famously said that before you commit an action, you should ask yourself if Allah will be pleased with that action. And so that is something that, for example, somebody could put into their will and testament as advice for people that they leave behind. Secondarily, you can put funeral and burial rites. So those could be specific instructions about what you want done. They can also specify that there are grave plots out in a certain cemetery that somebody owns, and their preference as to where they wish to be buried. I've had clients obviously say they'd like to be buried next to their spouse, sometimes next to their mother, and sometimes there'll be a specific area in a graveyard that's been allocated towards a specific family. Then you can get into what I will speak about further with some examples later, which is the waqf or the awqaf, if you, for example, set up multiple endowments. And so the waqf would state that you're giving up to a maximum of 1/3 of the estate for gifts to a charity, one that either you set up yourself or where you're sending to existing charities, of which there are, of course, many in Toronto, Ontario, and Canada, and obviously the rest of the world. And I find that clients very much have a global outlook. So, for example, they'll want a well set up in India or Pakistan, or they'll want monies specifically allocated towards orphans in Syria and Yemen, and other specific needs that they have in mind. And then the third or the fourth component of the will could be Sharia-compliant estate planning. One good example I like to give is there's a famous businessman called Philip Granovsky. He did what they call a dual will, which is one will he set up for the major assets like his home, major assets that many people would already have. And then he set up what they call a secondary will, which was for the shares of his private corporation. And so that was actually the more valuable part of his estate. It was worth a very significant amount at the time, $25 million. He'd built the business from scratch, and he had obviously a good lawyer who drafted a primary and secondary will. It was only the primary will that was set up and established in the court system, and then the secondary will allowed him to save $375,000 for his estate. So people who are running a business, even if it's a startup business, should consider doing a dual will, because they could protect what may end up becoming very valuable shares from estate taxes. So in terms of the preamble, I have a few samples here that I'd like to share of people who have written their will, and I can set these out. These are from a book actually I've written on the subject, and I'm going to read out some sample passages from wills that people have done. First example is, my family and friends have been a source of strength and happiness throughout my life, and I request them to honor this by keeping close ties with each other and the relatives and friends of their parents, and ensure that their children do as well. I request of all of my immediate relatives and closest friends, for the sake of Allah and out of fear of Him, to settle their disputes and correct their relationships among themselves according to the following orders of Allah in the Holy Quran. So fear Allah and amend that which is between you, and obey Allah and His Messenger, if you should be believers. That's from Surah Anfal, verse number 1. I request that if you differ in anything amongst yourselves, you refer the decision to Allah and His Messenger. For Allah said, and know by your Lord, they will not believe until they make you, O Muhammad, judge in what they dispute amongst themselves, and then find no discomfort from what you have judged, and submit in complete submission. That's from Surah An-Nisa, verse number 65. I remind them that no person dies before their time. The exact duration of each lifespan is precisely determined before we are born by the all-powerful Creator. May He be exalted. Death is tragic only for those who lived out their lives in self-deception without submitting to the Creator and preparing for the final return to Him. So do not preoccupy yourselves with my death, but instead make the proper preparation for your own. Maintain patience and self-composure, as the religion of Islam requires. Islam permits relatives to mourn for no more than 3 days, although a widow is allowed to mourn for 4 lunar months and 10 days until her iddah is completed. Wailing and excessive weeping is forbidden by the Creator, and it only reflects lack of understanding and dissatisfaction with the will of the Creator. May He be exalted. Although discretion has been given to my spouse executor in the distribution of my estate, I implore my spouse executor to think of me wanting just another opportunity to do as many good deeds as possible, whereby every single sadaqah would mean a lot, to let them keep what they must and give away the rest in sadaqah-i-jariyah in the most beautiful manner as soon as possible. May Allah accept it. Lead your life based on Hasbunallah wa ni'mal wakil, and surely Allah will make it easy for you. Here's another example. Let those executors and guardians fear injustice, as if they themselves had left weak offspring behind and feared for them. So let them fear Allah and speak words of appropriate kindness. Indeed, those who devour the property of orphans unjustly are only consuming fire into their bellies. And as the Quran warns, they will be burned in the blaze of hellfire. That's from Surah Nisa, verse number 10. Very serious stuff, obviously. My final bequest for my family and children is the same one that the Messenger of Allah, peace be upon him, enjoined upon his followers, the prayer. I advise and implore my family to have patience and accept Allah's will. This concludes my last will and testament. I am now free in front of Allah from any words and deeds that distort and contradict this document, according to the guidance of Allah's Messenger, as forewarned by the Quranic verse. Then whoever alters it, after he has heard it, the sin is only upon those who have altered it. Exalted is your Lord, the Lord of might, above what they describe, and peace be upon the messengers, and praise to Allah, Lord of the worlds. Final passage there is from Surah As-Safa, verses number 180 to 182. So those are some good samples. People with more Sufi inclinations have put things that they would like to be done, perhaps at a Sufi fellowship, either here or in the United States. And so that would be the preamble to the will. And as I mentioned, there would be funeral and burial rites that would follow thereafter. And there would be provisions made for payment of debts. For example, that's a very serious obligation in our tradition. As we know, many people in the minbar following the passage of a family member will say that they will honor the debts of somebody who's passed away if those debts haven't been paid during someone's lifetime. And then with respect to the awqaf, obviously those are important provisions, and those can only be up to a maximum of 1/3 of somebody's estate. And then when we get to the Sharia compliant estate planning, there are samples. For people viewing this on video, this is a sample schedule that would go into a will and testament. And so an example of one distribution would be if somebody left behind for a husband, 2 children, a son and a daughter, and no parents. The Islamic distribution would be 1/4 to the husband, who would otherwise get a half if there were no children. But on top of that, there would be 1/4 to the daughter, and the remaining half would go to the son. So very often, this doesn't apply in Ontario because of the way the assets are already structured. So let's begin, for example, with the matrimonial home. That tends to be jointly owned by husband and wife, and it tends to be by way of joint tenancy, which means that 100% of the property will end up going to the survivor. Then on top of that, we have the bank accounts, and those also tend to be jointly held. A lot of the time people maintain separate accounts, but the very heavy accounts tend to be in the name of both spouses. So if that's jointly held, once again, it's going to go to the spouse. If there are RSPs where there's a beneficiary that's been designated, that also tends to be the spouse, and that will go directly to them. And then life insurance, even though it's not Sharia compliant, a lot of people end up getting it through their work. And once again, the spouse tends to be the beneficiary. So those 4 major assets, the home, the bank accounts, the life insurance proceeds, the RSPs, would end up going directly to the spouse. And even if the will had Sharia stipulations, they would be deemed irrelevant. Some variations of that people can do are, for example, putting in that even though the spouse is jointly owned, I'd like the distribution to be as per Sharia. One step further than that is to actually sever the tenancy of the property. So 50% goes to one spouse, 50% goes to the other. And so if one of the spouses pass away, 50% they will keep, but the other 50 will be distributed as per the will. So that's one thing spouses can do to bring certain assets closer in line with the Sharia, but obviously they'd have to get advice from both an imam and a lawyer with respect to the best way going forward, because one of the complications that arise if you put, let's say, the children on title to reflect their Sharia inheritance would be their spouse. The child's spouse can potentially lay a claim on the spouse's share and force the sale of the property. So one option to do then is put a lifetime interest of the spouse, surviving spouse, onto the property, so nobody can sell the house during their lifetime, even though other people have a share in that property. And so once again, it's important to keep that in mind in structuring your affairs. So then with respect to the bank accounts, very often if there are TFSA accounts or things that are more exotic, you can put beneficiaries listed in those accounts, and you could put the Sharia distribution of those beneficiaries, so the spousal share and then the sons and the daughters on those accounts. Same thing could apply with an RRSP or life insurance proceeds. You could put the Sharia distribution of the beneficiaries in those accounts, but there are, once again, complications that arise. For example, Canada allows an RRSP to be rolled over to a spouse on a tax-free basis. But if the children are going to inherit some of the RRSP, then those would obviously attract taxes. So let me just speak in more detail about some of the tax consequences that arise. As we know, with respect to the principal residence, that is a tax-free asset. That's an exception that Canada has made to taxes. The only time it would attract taxes is if, let's say, the property is in the name of one of the spouses only, they pass away, then there would be probate taxes payable on that property, which would amount to $15,000 of every $1 million in value of the matrimonial home. Turning then to the bank accounts. So let's say, or even cash. The idea would be that you've already paid taxes on those accounts, so they would be on a tax-free basis. But once again, if there's no spousal rollover, because the account is not jointly held and it's only held by one of the spouses, then that's going to attract probate tax. So let's say, for example, an account has $100,000 in it, that would attract a nominal tax of $1,500 on that account. With respect to the RRSPs, because taxes haven't been paid on them on somebody's passing, there is what they call, the tax authorities called a deemed disposition, which is essentially a transfer of that asset to the spouse and taxable consequences for the sale of those shares, the deemed sale of those shares on which taxes are paid. The only exception to that, as I mentioned, is a spousal rollover into their RSP. Finally, with respect to life insurance that people often get through their work group benefit plans, that would go directly to a beneficiary, but if there was no beneficiary designated, it would pass through the will, and then it would attract taxes. So for a $500,000 policy, that would be $7,500 in taxes, which of course may be nominal if you're inheriting a policy of that size. So those are some of the tax consequences. I think Muslims obviously have to bear tax strategies in mind from a Sharia perspective. Obviously, all debts have to be paid, and if they are taxes owed to the government, those would have to be paid as well. I think that would come under the same category. But there are some mechanisms that you can use to get around some of the more significant taxes. Like I mentioned, if you do a dual will because you own a private corporation. So this applies to private businessmen, of course, to doctors, lawyers, accountants, all of whom can have professional corporations and often make investments through those professional corporations. So the last topic I'd like to cover is an important one. People obviously are keeping in mind charity as we approach the final days of Ramadan. Zakat is obviously recommended to be paid within the holy month, although it can be paid in advance, obviously. But in terms of thinking about zakat, and in terms of thinking about sadaqah jariyah, and in terms of thinking about waqf, this is an important component of the will within the Islamic context, because the only discretion that somebody has is over 1/3 of their estate under the Islamic tradition. And that 1/3 could be given to, for example, a non-Muslim relative, like a spouse, obviously in the case of a husband giving to a non-Muslim spouse, or it could be given to an adopted child who would not otherwise inherit under Islamic principles. So that 1/3 could be used to give to an adopted child. Its more important use, of course, is for awqaf, and that could be given to a masjid. It could be given to an Islamic institution, such as a school. It could be given to an orphanage. It could be used to set up water wells and things of that nature. And I've got a few examples here from Islamic history that I would like to share with you. And once again, this comes from the book on this subject. And so this is in a chapter called Charitable Giving, the Waqf Institution. There is great historical and religious precedence for establishing awqaf. The Prophet Muhammad once inherited 7 orchards by will, which he made into a waqf for the poor. The second Khalifa, Umar ibn al-Khattab, made the whole of Iraq a waqf for the benefit of the Muslims, and awqaf land covered about 1/3 of the Ottoman Empire. So then there is a very famous anecdote in our tradition about the Holy Mosque in Medina. And this says that the waqf, however, is for God. And waqf property was to be immobilized forever and could be from trust land itself. So that's a legal principle, that waqf is once it's given over to somebody, to a religious institution, is for God only and can never revert back to a person or people. For example, the Prophet Muhammad purchased land from 2 orphan boys to build a grand mosque in Medina. As the narration goes, after his migration from Mecca to Medina, known at the time as Yathrib, the Prophet's favorite camel, Qaswa, came to rest at this spot in the center of Medina. When the Prophet alighted, he asked who the courtyard belonged to and was informed that it belonged to 2 orphans under guardianship. The Prophet asked if they would sell him the courtyard and told him to name a price. When they offered to gift it, the Prophet refused to take it, and a price was fixed with the assistance of a guardian. The Khalifa, who were companions of the Prophet during his lifetime, were also active in establishing a waqf. Umar ibn al-Khattab came to the Prophet and asked him, "I've got a land in Khaybar, than which I have never obtained more valuable property. What do you advise about it?" The Prophet replied, "If you like, sequester its principal and give away its yields in charity." So that means to keep the principal of the land, but any rental income or any produce, such as dates that come from that land, can be given in charity. So Omar made it a charity on condition that it not be sold, nor given away as a gift, nor inherited, and made it a waqf for the poor, kin relations, to set slaves free, for travelers, and to entertain guests, where there was no blame on him who managed it if he ate from it and made others eat, not accumulating wealth thereby. There's also an anecdote about the Khalifa Ali ibn Abi Talib, who was given farmland in Yanbu, close to Medina. He discovered a spring on the land and called it Bughaybiyah, from the bug sound of gurgling, rushing spring water. Immediately recognizing the value of the spring when he discovered this land, he exclaimed, "Give my heirs the good news," and turned the spring into a waqf to serve the poor, travelers, and members of his family in need, and placed the endowment in charge of his sons Hassan and Hussein. Ali's great-grandson Abdullah was tending to Bughaybiyah, and he was tending a reed bed fed by a spring of his in the farmlands of Yanbu. There's a very famous case that arose out of that land that was given and passed down through his inheritors. Within one's lifetime, there is no limit on giving in waqf, and in fact, the Sharia stipulations don't apply to gifts. So if you're giving gifts to your children, the Sharia principle is there should be equality between the gifts. But once somebody's on their deathbed or suffering from a terminal illness, then the Sharia stipulations kick in. And as mentioned, waqf and the discretion over somebody that has a will would be on the 1/3, but 2/3 is already spoken to by God. So with respect to the 1/3, the Prophet, peace be upon him, had important instruction. So he said, "It is better to leave your offspring wealthy than to leave them poor asking for help." And this came from a hadith where Sa'd ibn Abi Waqqas was stricken by an ailment, led him to the verge of death. The Prophet came to visit him, and he said to him, "I have much property and no heir except a single daughter. Should I give 2/3 of my property in charity?" "No," the Prophet replied. He asked, 1/3 of it? He said, "You may do 1/3, but even that is too much. For it is better to leave your offspring wealthy than to leave them poor asking others for help. And whatever you spend, you will be rewarded for it, even for a morsel of food which you may put into the mouth of your wife." Jazakallah. May you have the blessings of the rest of Ramadan. It's been my pleasure to speak to you. Ameen.
حق الله والله يا الله والله حق الله يا الله حق الله والله يا الله